We have been sent to protect and to defend.
We won't relent. We will fight until the end.
We have been sent to protect and to defend. Let justice flow like a river to the ground. Let justice flow like a river till only freedom is found. We count the cost. We will pledge our very lives. All nation lost, but the kingdom will arise. Let justice flow like a river, flow from the peak to the ground. Let justice flow like a river till only freedom is found. Let justice flow like a river, flow from the peak to the ground. Let justice flow like a river till only freedom is found. The coastlines will know. The coastlines will know. The coastlines will know your justice. The islands will know. The islands will know. The islands will know your justice. The nations will know. The nations will know. The nations will know your justice. The coastlands will know. The coastlands will know. The coastlands will know your justice. Let justice flow like a river. Flow from the peak to the ground. Let justice flow like a river till only freedom is found.
Good evening. Good evening, Council. I hope you are well. Welcome to Land Law in Zambia, and we are going to start by looking into the various topics that have been highlighted on the screen right now. So we're going to start by introducing land law in Zambia. We'll look at the concept of ownership, and lastly, we'll look at fixtures and fittings. These are very, very important basic topics in land law, and anybody who's doing land law should actually be able to appreciate this. Now, I am going to try as much as possible to, give a particular relation that is very, very close to land law, especially when you're looking at it from the point of view of conveyancing, so that to give you a baseline understanding of what you need to take home insofar as the course is concerned. So now let us get right into the lesson for the night. Okay, so introduction to land law. Now, what is land law? Or before we even go to what is land law, let us set the foundation upon which this course is built on. So land law, or law of real property, as it is called in other texts, if you ever find books that are named as law of real property, it is actually one and the same thing. It is primarily concerned with the ownership of land. That is its primary focus. And the word ownership, as you begin to appreciate when we delve deeper into these particular codes, has several interpretations which are very, very distinct and different. They are very different interpretations of what we refer to as ownership in land law. What you regard generally as being ownership and what is regarded as ownership in land, or when you're dealing with land in the legal space, are actually two distinct aspects. So what is important for you to take into consideration is what will ownership mean in regards to land law, which we'll come back to later on, so that we emphasize more on the concept of ownership. But introducing the course itself, land law is primarily associated with the ownership of land. Now, land in its broader interpretation, especially when you're looking at it from the point of view of the legal system, is not entirely relating to the physical manifestation of what we refer to as land. It focuses on, or even goes beyond, just the physical manifestation, and focuses on looking into the interests that are vested in this particular property that we're referring to as land. So despite the course being called land law, it deals with other aspects that are attached to the land. For example, it could be dealing with the house. It could be dealing with interests that are on the piece of land itself, such as the right of way, which can exist for persons who do not necessarily own the piece of land, but use the land that you occupy at that particular moment to get access to their own piece of land. So it deals with not only the land itself, the manifestation, the physical manifestation itself, but also the interests that are embedded in that particular piece of land. So what are we dealing with when we're dealing with land law? We're just basically dealing with that corpus of law that is primarily focused on regulating the interests that are in and on land. It regulates the legal interest and the equitable interests that are on that particular piece of land. Therefore, for us to appreciate it even more, we say for this particular area of study, it has two dichotomies. The first one is the one that deals with the interests of land, which is the course that we're dealing with right now, which is basically referring to aspects such as leases, such as mortgages, such as easements, and just generally the law that regulates how land in Zambia as a specification is concerned. Then the other sphere of it deals with issues of liability that can accrue to persons who own the land or persons who get access to the land. So it is one and the same thing. And for this particular course, we'll definitely delve deeper into these issues. Okay, now let's draw a relation as well. So there's a relation that is there between the law of real property or land law and the course called conveyancing. Conveyancing deals with primarily the practical aspect of land law. So in order for you to really get a hold of conveyancing or really appreciate conveyancing to the level that you need to be able to properly understand the concepts, the doctrines, and the laws that regulate land. Without a foundation in land law, conveyancing becomes very, very problematic for you. Megary's Manual of the Law of Real Property observes that the objectives of learning the law of real property are to acquire knowledge of the rights and abilities that are attached to interests in land and to lay a foundation for the study of conveyancing. Basically, just reiterating what I've stated to you. You need to be able to have a good appreciation of the law of real property, because this is what is going to set the substantive foundation for you to really be able to get a hold of or just understand conveyancing at one point in time as you're doing your legal studies. So you firstly need to understand land law. It's very, very important, or the law of real property. Okay, so from there we go into the proprietary nature of interests in land. Now, I am going to come back to this at a later stage as we go on, as we try and look into issues of equity and the existence of common law at the same time. But what you need to understand is that there's this issue that deals with what is known as proprietary interests. So if you're dealing with, for example, the transfer of land, what you should expect as counsel, or what you should expect as a person who is dealing with law, is that your transactions are going to have two parts. There's a portion of it that deals with issues of contract, and there's a portion of it that deals with proprietary interest. So you can be dealing with an issue of contractual interest, but at the same time also be dealing with the issue of proprietary interest. Now, what is proprietary interest? To just put it across, what is proprietary interest? Dixon, in his book The Law of Real Property, goes on to recognize these interests as basically being land law rights, and he categorizes them into two: that they are interests that are vested or that are in existence in law, and there are those that are in existence in equity. So whenever you're dealing with property or proprietary interest, the interests are going to be in existence either in these two spheres. You can be dealing with legal interests, that is those that relate to the application of common law, or in this particular regard, those interests that are changing as a result of the operation of law, statutory law, which is strict law. And you can also be dealing with an issue that deals with what? Equitable interest, because you may have acquired a particular portion of land for the purposes of doing whatever that you've set out to do through that transaction. You buy maybe from the president directly, because we're supposed to get property from the president according to the Lands Act. So you buy the land from the president, and then that transaction that is there is one that is vested in statute. It's one that is backed by strict law. But also at the same time, you can find yourself being buying property from another person who on that particular person may have given or may have consented to an easement existing on that particular piece of land, or a profit existing on that particular piece of land. So you definitely need to be aware that there is this issue that I'm dealing with whenever you're dealing with land. Interest in the lands can exist as a matter of law or as a matter of equity. So that's how the nature of proprietary interest really is. And when you're saying I'm dealing with proprietary interest that exists in law, what are you dealing with? You're dealing with issues of leases. You're dealing with issues of mortgages. When you're saying I'm dealing with an issue that is purely in equity, you can equally find yourself dealing with something that comes from equity, like profits, as I have earlier alluded to. For your own understanding and to further expand this issue of proprietary interest, please read the case of Mark Chona versus Evergreen Farms, 1996. Now, this case is unreported, but you can find a sample of it or a script of it from the book Land Law in Zambia by Frederick Mudenda. If not that, a simple Google search will actually make you to be before this particular case. Now, we can never really speak to law without establishing what the sources are to law. So it is very, very important for us to speak to the sources of land law here in Zambia. What could be the sources of land law in Zambia, and why do we think they are sources? So the first one, of course, is the Constitution of Zambia, Chapter 1 of the Laws of Zambia. And itself, it recognizes various parts of this particular piece of document. It recognizes that it regulates land, or how land is dealt with. Land issues are dealt with here in Zambia. There are specific provisions in there. The number one answer, mostly whenever you're dealing with the Constitution, will most likely be, Article 1:1 says it is the supreme law of the land, so it is the mother, it gives birth to law. There's no problem in that. There's literally no problem in that. But the problem is, can we prove that the Constitution is a source of land law in Zambia? So to prove that, the preamble, to start with, recognizes the commitment of the document, the commitment of the Constitution to upholding human rights and fundamental freedoms. Now, a portion of these human rights and fundamental freedoms deals with the protection of property and land rights. These are equally expressly reflected in the Bill of Rights itself. For example, under Article 16, you would find the protection of land and property rights, where there's an express prohibition in the first instance to the powers that be, or the president, or the government, since generally it's a government, from mandatorily acquiring portions of land that belong to the private citizens. They can't do so in the first instance. There's an express prohibition whereby if any government official or the government itself mandatorily acquires your land outside the prescription of what the law states, then it is going to be considered as a breach of your rights, the rights that are recognized and protected in the Constitution itself. Despite this being provided for there, the provision equally creates an exception. So there are circumstances where your property can actually be mandatorily acquired. And the law in the Constitution says that particular power can only be exercised if there is legislation that is speaking to it. And there are several legislations that have actually spoken to this. The primary piece of legislation, of course, being the Lands Acquisitions Act. I will come back to this at a later stage when we deal with mandatory acquisition as a topic. But for now, it is very important for you to know that the Constitution provides for a protection. Though it provides for a taking away of the right, it equally provides for a protection. You can see in advance the case of Zambia National Holdings Limited and the United National Independent Party, or UNIP, versus Attorney General, 1994. This particular case dealt with what we now call government complex, that big building where we find various ministerial offices. Before it was turned to government complex, and before those developments that have been made currently were made, it was just one building, which was UNIP headquarters. When it was being built, they used funds for the people of Zambia. So it was mandatorily acquired by the government. And that particular case will explain to you what was the issues in that particular case. Of course, satisfying the two basic and primary conditions for a mandatory acquisition to be legal. That is, that they should be the acquiring in the first instance should be for a public purpose, and secondly, that there should be compensation, which is equally recognized in the Article 16. Now, I'll come back to this at a later stage. Aside from that, there's also Article 233 of the Constitution Amendment Act number 2 of 2016, which establishes the Lands Commission, a principal constitutional body responsible for the administration, managing, and alienation of land on behalf of the president. So if you can cite these provisions, if you can speak to these provisions properly, you have successfully proved that the Constitution of Zambia is equally recognized as a source of land law in Zambia, or we can get land law from the Constitution of Zambia. Now, apart from this, we have various statutes that have been enacted by the Zambian legislature. Part 6 of the Constitution of Zambia creates what is known as legislative authority, or the powers to enact law. So by conferring this power on National Assembly, the National Assembly itself has been granted power to create pieces of legislation. There are specific pieces of legislation that have been created that deals with land administration. And some of them includes the Lands Act, the Lands and Deeds Registry Act, which was quite recently, part of a very big debate, and before in the public. So there are specific pieces of legislation that regulate issues of land. So if we're going to take one as an example, we can go to the Lands Act. The Lands Act confers land in the hands of the president. It creates these particular interests or power that has been given to the president to hold land on behalf of the people of Zambia. So if you're answering, maybe say the question of who owns land in Zambia, we can say the Zambians are the ones that own land in Zambia, but they have placed that particular land in terms of control in the hands of the president, who only exercises his power of managing or regulating in and on behalf of the people of Zambia. So that is what you can pick out from there. Then we have, of course, English common law and principles of equity. Now, chapter 10 and chapter 11 of the laws of Zambia, which is the English Law Extent of Applications Act, which is chapter 11, and the British Acts Act, the British Acts Extensions Act. That those two pieces of legislation provides for the application of both common law and equity here in Zambia. To emphasize on common law, there are several principles actually that are applicable to Zambia in respect to, or that are derived from common law. There are several of them, and even legislation that applies to Zambia. For example, the Married Women Properties Act, which is an English-born piece of legislation, is made applicable to Zambia. English common law, of course, we can remember from our legal process foundation that it is just that law that was applicable to Zambia, to England rather, after the Norman's conquest. And because we're a British protectorate, we have adopted some of the principles and some of the laws to be applicable to here, that to be applicable here in Zambia. Aside from common law, there's also principles of equity. There are several principles of equity that exists that are applicable in respect to land. And quite recently, the Court of Appeal, in the case of Musoloni, Chipabwamba, and 12 others, versus Yourselves Enterprises Limited and others, Appeal number 104 of 2020, the Court of Appeal was dealing with an equitable principle and how it relates to matters that are purely regulated by statute in respect to land, and how equity comes in to chime in regulating how the interests are going to be balanced. And you can get access to that particular case for the purposes of emphasis. But as a source of land law, we can basically say that indeed it applies to regulate how equity, or matters of equity, are actually dealt with here in Zambia. Then we have customary law. Customary law. Of course, we are a dual legal system. We have a dual legal system, which basically means that we apply both strict law and also the law of the indigenous communities that were resident here in Zambia before Zambia was born, and even afterwards. So there are several ethnic groups that abide by different beliefs and customs that regulate their entire groups. So here in Zambia, we recognize that even that particular law that regulates those tribes is valid, and to a greatest extent, there are several customs that actually regulate issues of land, especially when you're dealing with it from the point of view of inheritance. There are several cases that you can speak to that relate to land, and just how customary law has a role to play in its regulation. In fact, in the recent case, the same Chipawamba and 12 others case that I referred to, there is a component of it that looks into issues of customary land, or land that is under the communal regulation of chiefs or indunas or whatever they are called in respect to these different tribes. So we have customary law that regulates how that is supposed to be done, or how land is actually looked at in that particular respect. And we can see a codification of the recognition of the customary law in the Lands Act itself, specifically Section 3, subsection 4, which clearly indicates that the president, who is the president of the Republic of Zambia, shall not alienate land that is situated in a customary area, recognizing these communal interests that is vested in land held under customary law. So we can look at customary law as a source of land law here in Zambia. Then we have judicial precedent, which is basically case law, and we recognize that whenever there is a superior court's decision that has been made in respect to land, it automatically binds all the lower courts, and this is paying credence to the principle of stare decisis in Zambia, which basically means standing by the decided. So judge-made law is equally applicable, and it guides on issues of land. Other than that, we also have textbooks, so juristic works of individuals who are of a high caliber, who have of a high caliber in Zambia, influence on how land is actually dealt with here in Zambia, and this is mostly because of the jurisprudential value of the writings of various individuals. And I earlier on referred you to a book written by Frederick Mudenda, the land law in Zambia. So it helped in some way grow the jurisprudence in respect to land law in Zambia. So it has jurisprudential value. So any other books that is cited, especially books like the Megari Manual of the Law of Real Property, which has been overly cited in different cases, has helped judges understand certain concepts and equally decide cases, thus making them of value. Of course, these sources are in a pyramid of hierarchy in terms of which one is superior to the other. So even their value is equally regulated by that particular hierarchical hierarchical positioning, which is not the subject matter of this particular lecture. But it is very important for you to understand that these are the sources. These are the primary sources of land law in Zambia. So if you want to deal with land law in Zambia, you firstly look into these sources. They're going to guide you in one way or the other. Okay, so we go now into what is known as the doctrine of tenure and estates. The doctrine of tenure and estates. And I'll firstly start by looking into the doctrine of tenure. So tenure, or the word tenure itself, is derived from a Latin maxim called tenere, which means to hold. So the doctrine of tenure relates to the conditions under which land is held. So under what conditions is a particular piece of land held? And for us to really appreciate this, we need to go back to the 1066, or 1006 years back, because this is when now we really saw a primary focus, or the primary role of the legal framework in regulating issues of land. So after the Norman's conquest, that is after 1066, and William the Conqueror became a king, if you can call it that, of modern day England. There was this legal system that was created, and in regulating matters in that particular system, they introduced rules and laws that regulated how land in particular was supposed to be held. And as you can see from this narration, you can see that at that time, in fact, even up until now, one of the highest or the most valued interest or item in the world is actually land. So how it was being held was equally a matter of regulation. So after 1066, there was a concept that arose, which is known as feudalism, or it was basically a situation where the highest sovereign, or the overlord as it was called at that time, William the Conqueror, was the one who held land in England and all its colonies. So everybody who wanted to own a particular piece of land was required rather to meet certain conditions. And this is what tenure deals with. So these conditions included providing military service, and it also it also dealt with issues of paying a particular amount of money for you to be given a portion of land. So this is where feudalism came in. Now, because there were huge chunks of land, and there were a lot of land at that time, this created a situation where the overlord, who was William the Conqueror, and all his successors at that time, held everything. Then he gave it down to another person who was equally a landlord, and they ended up giving it to other people, creating what is known up until this time as sub-infeudation, or where the land was sub-infeudated. So now even them, they equally in enlisted individuals who were providing military service or who were paying them a particular portion of money for them to get a hold of property. And that was the then issue at that time when it came to the conditions under which land was held. So you were supposed to provide a military service or religious service or whatever it is so that you can get land. That's how it was. So at the time, all land was actually vested in the crown. That is after after the Norman's conquest. Land administration underwent significant changes after that. There were a lot of legal, there were a lot of changes in the legal system, especially in relation to how land was held, or the conditions under which land was held. And there were several introductions of pieces of legislation or law that actually looked into several issues. Remember, at the time, or before even these developments, human rights was an issue that was very much unheard of, and several regulations were purely based off what one particular person said to be the status quo. So after some time, there was a lot of debate, and because of the influence of developments such as human rights, there was an abolishment of certain issues. So the first development that we can refer to is the Quae Emptores of 1290. This particular piece of law firstly abolished sub-invitation, and it introduced a mechanism where every free man was given liberty of alienating his land without the consent of the overlord. Because before then, you could not give land to another person without the consent of the main the main owner, who was the one who held the crown at that time. So it dealt away with that issue of sub-invitation, and it allowed everybody who had land to do whatever they wished to do with the land, especially in relation to the alienation of the land. Aside from that, it equally encouraged substitution of the tenant. So it wasn't just an issue of just dealing away with the land. They could equally give land to another person who was not a previous owner at that time. Then we have the Tenure Abolitions Act, the Tenure Abolitions Act of 1660, which had equally several other benefits. Okay, sorry about that. So yeah, we had the Tenure Abolitions Act of 1660, which had several benefits as well. It completely abolished military and religious feudal tenures, so there was no need for you to serve up your services for military for you to get land. It introduced rather what was known as socket tenure, which basically just involved you paying rent or fixed mandatory duty. And this is actually a version of what we have here in Zambia, where you need to be paying your land rates. So it's a system that is quite similar to sockage at that time. It equally, attempted to do away with issues of feudalism as well. It abolished several burdens and dues and taxes that were a requirement at that time for you to have access to land. It brought in standardization and simplification in terms of how land was moving from one person to the other, and it removed issues of monarch military rights over subjects, where the monarch could actually just call you up and you start giving service to the military for you to continue holding that particular piece of land. So those are some of the benefits that were seen from that particular act. Then we had the most advanced of them all, which is the Law of Property of 1925. This particular piece of legislation is one that actually started the modern land law framework in England and in other British colonies. So it, as benefits, it brought in mandatory use of deeds. So before then there were no deeds, but now there was an issue of deeds. So you can have your deeds, and you have to register the deeds as well. So that was existing as proof of you being an owner of the land. It also reduced the legal estates, which I'm going to talk about in just in a few moments. Legal estates in just two, which basically being with the two being freehold and leasehold. So those are the only those were the only estates that were recognized in England and all its colonies. Okay, now let us go to the doctrine of the state. Now, the doctrine of the state, or a state itself, looks at the length of time for which land is held. The length of time for which land is held is called a state. Yeah, that is in land law. It recognized that a person cannot own land, but can only own an interest in land for a specific duration. That was the principle there, and it still applies up until now. And like I earlier stated, there were two concepts under estates. One was freehold, and the other one was leasehold. Under freehold, that's where we found concepts such as fee simple, fetal, and life estate, dictating how land was held at that particular time. Of course, when you talk about things like life estate, we're saying at common law, the ownership of land can be tied to a particular person's lifespan. So after you die, the interest went back to the president. There was fetal as well, which was issues of inheritance were actually at play at that particular time. So if you own land under fetal, then you had an inheritable estate which lasts as long as the original grantee and any of his descendants live. And this was an issue of of inheritance. You can own land and then you can pass it on just like that. Fee simple was one, or is one, condition that was very close to owning land absolutely, because of the interest and the entitlements that came with the lands that were held under this particular condition. By virtue of the Lands Conversion of Titles Act of 1975, freehold estates were actually done away with, and the law introduced what is known as leasehold here in Zambia, where there were two conditions under which land was held, and up until now, actually, it's very much like that. The Lands Conversion of Titles Act created an estate which is called in conveyancing a statutory lease, which was essentially given a particular person, those who held land, especially under the fee simple condition of owning land for a period of 100 years, a renewable period of 100 years, which was created by statute. So the time started counting in 1975, on 1st July 1975. So 100 years later, this is when that particular statutory lease will conclude. And this is very important, especially if you're taking conveyancing, because it plays a role on how you're going to draft certain documents that relate to how interests are shifting. Then it also created leaseholds, and these leaseholds, like the one that I suggested, it equally looked into issues of getting a presidential lease, which is you are owning land for a period of 99 years, which is currently the framework under the Lands Act. Okay, so there's also the doctrine of tenure under customary law. And like I said, there's an issue of customary law that usually comes to play whenever you're relating to this type of regulation here in Zambia. And it's very, very important that we understand this, because there is still land that is being dealt with under customary law, where you have to go to different chiefs or to a chief for you to get a portion of land, and they definitely set their own terms. What you need to know about tenure under customary law is that chiefs who have been given functions or have been given the function of exercising control over land, they can set their own terms, and the terms are different on how you're going to use that particular piece of land. There is a regard that whenever land is under a customary area, then there's communal ownership of land, meaning the land is owned by everybody who's in that particular customary area, and they give it in just like the way it is with the president. They give it to the chief or the king as a custodian on behalf of the people in that particular area. So you can appreciate it in that way. In Ngowani and others versus from Info Farms Limited and others, the Supreme Court of Zambia held that under customary tenure, land can only be alienated if there's a consent of the traditional chief, because this particular piece of this law, this principle, this case dealt with the conversion of property, conversion of land from it being under customary law to it to bring it before or to converting it to statutory land, and that process cannot be initiated without the consent of the chief.